Hello everyone, good morning. Today is 30th of August and welcome to the Hindu newspaper analysis discussion. So guys, in this video we are going to take the entire discussion of the Hindu newspaper with the background and with the way forward. And meanwhile I would like to tell you that you can download this explainer PDF from the Telegram channel, okay, and the link for the Telegram channel has been given in the description box. Please follow this particular PDF along with the video for a better understanding of the articles. Now let's start. First of all, let's take the overview of the entire newspaper in order to understand that which articles are important in the today's newspaper. So the first article is a political article, not important. Amid floods, Pakistan open to restart the trade with the India. Now in this particular direction, we'll see the potential of the India-Pakistan ties, trade relations, violent crimes in country back to pre-COVID levels. So guys, the National Crime Record Bureau report has been published. So we will see some of the important highlights in that particular direction. Reliance to start the 5G services from October. Fine. Then guys, moving on, basically then again the political articles etc has been given, not important, or no need to go in that particular direction. Then again the NCRB's report is being discussed. We'll see this particular article. Moving on guys, then after that the advertisements etc has been given, not important for your UPSC examination. Fine. So directly guys we'll be reaching to the editorial page. So till the editorial page, much important things are not there. Then there are no easy answers to the freebie issue. We'll see this particular article. Fine. Then guys, curing the patriarchal mindset of the legal system. We'll see this particular article also, that how there is a need of teaching the feminine jurisprudence. All these things we are going to see. Then guys, the Congress conundrum. Okay, so basically guys, this article is talking about that the organizational poles must stir its workers to life. So basically we have seen this thing that there are many of the crises going on in the Congress. Many of the senior leaders have exited. So in that particular direction the article is talking about. So guys, the political article not important for our UPSC examination. Then the power play. So guys, recently we have seen multiple number of times that the All India Football Federation was banned by the FIFA. Now this particular ban has been removed. Clear? Then moving on, after that, challenges of subnational fiscal correction. We'll see this particular article with respect to the examination, GS paper number 2. The new facets of terrorism. This article also will be seen with respect to the UPSC. Jurisprudence of bail. This article will see with respect to GS paper number 2. Najib Razak and the and 1MDB scandal. So guys, this article is talking about the 1MDB scandal. Fine, the fall of the Prime Minister of Malaysia, etc. Now guys, this is an internal issue. Fine, and with respect to UPSC, our examination, the article is not much important. Then moving, explaining Pakistan's flip-flop of trade. So we'll see this particular article, the relevant issues. Then moving on, after that guys, the political articles etc has been given, not important. Minority status plea, government seeks more time. So we'll see this entire issue, that what's the issue is all about. Then guys, the political articles not important. Here the violent crimes, with this particular report, the NCRB report will already be taking it up. Then IAF to induct the first light combat helicopters. Okay, so guys, basically see these kind of things, that okay, the light combat helicopter is being inducted, how many of them are being inducted. So on UPSC such kind of questions have basically are not very much important. Then the political articles etc they come, not important. New system soon to list cases transparent. Once it will be coming, we'll see that what has happened in that particular direction. Okay, fine. So that particular thing we'll see that once it will happen. Then guys, moving on in this particular direction, after that Chinese troops stops grazier in the Ladakh, not important for the exam. Tribe categorization work delay benefits under the seed. So guys, this particular seed scheme, what this seed scheme is all about and all those things, we'll see this in this particular article. Then moving on, after that guys, onto the world page, Sadr's followers storm Iraq government palace, snag postpones the NASA's moon launch. Fine. Basically all these particular articles which have been provided are the evolutionary details that have come in this particular direction. Fine, no need to go too much into the detail with respect to the examination. Then on the business page, fine, Reliance India Limited, Sensex etc are being discussed. Then the RBI mulls fraud registry to help banking frauds. We'll see this particular article with respect to the examination. Then guys, the corporate trends etc have been given, and after that we have the sports page. So that is all guys about the articles in the today's newspaper, and now let's discuss all these articles one by one in the detail. Okay, now let's discuss them. Okay, first of all, guys, can you tell me, are you able to see me? Is the stream visible? Is the voice audible? Everything is fine? Okay, moving on. Now, in every class, we take the GS quotation. So, guys, in the today, we'll be taking the quotation from the Mark Twain. So, what the Mark Twain says? Mark Twain says that it is curious that physical courage should be so common in the world, and moral courage is so rare. Now, guys, understand this particular thing, that when we talk about the courage, there could be the two dimensions of courage. One's the physical courage, the visible courage. For example, let's say a tiger comes in front of you. Now, how you'll deal that particular situation, that is the physical courage. But apart from the physical courage, there is also the moral courage. Now, what's the moral courage? Moral courage is to take the stand for the right thing, to take the stand for the ethical things, and to raise your voices when the injustice is happening, when the wrong things are happening. So basically, this moral courage is very much rare. People don't even think that moral courage is a virtue that is worth aspiring for. Rather, everybody is fascinated with the physical courage. So rather than the physical courage, the moral courage is also equally important, and we need to search the moral courage also. There needs to be the aspiration towards the moral courage. Now, this particular idea can be used in GS paper number 4, ethics. This particular idea can be utilized. Okay, so that is all about the quotation for today. And now let's take the first article. Now, so the first article, the jurisprudence of bail. Now, this particular article is taken from the text and the context section, and the jurisprudence of the bail, etc. Guys, this issue is coming a lot in the news. Before going in this particular article, guys, we will be discussing some of the background. And after that, we'll understand that what this particular article is talking about. So recently, see what happened. Basically, Satendra Kumar Antil versus CBI judgment was given by the Supreme Court. And in this Satendra Kumar Antil versus CBI judgment, Supreme Court provided this particular thing, that what has happened in India, the bail are not being provided to the people who have been arrested. Basically, in India, the rule is that the bail is the norm and the jail should be the exception. Only in very rare circumstances a person should be put into the jail. But opposite is happening. What's happening? Jail is a norm and a bail is an exception. So basically, we find that the judiciary has moved towards the judicial conservatism, where the bails are being denied. And in this Satendra Kumar Antil versus CBI judgment, Supreme Court provided this thing, that we need to come out with the separate bail law. We also need to come out with a separate bail law. Fine, that is a particular thing that is happening. Okay, so this was the one development that happened. Then, guys, the second development that happened was one other judgment of the Supreme Court, and that judgment was the Vijay Madan Lal Chaudhary judgment. Now, in this Vijay Madan Lal Chaudhary judgment also, there were certain issues happened which impacted the bail. Basically, guys, this Vijay Madan Lal Chaudhary case was case with respect to the Prevention of Money Laundering Act. Now, basically, we have seen, if you are following the newspaper analysis regularly, we have followed this PMLA, Prevention of Money Laundering Act, in much detail. So we have seen that basically under this act, the Enforcement Directorate gets the power to arrest the people for the money laundering charges. Money laundering means that if a person earned money through some illegal mean, and if he is trying to convert that money, trying to show that money that actually I earned that money by the legal means, by the legitimate means, that is money laundering. Converting your dirty money into clean money, that is money laundering. So basically, ED had arrested the people, and guys, under the ED, the bail is very difficult condition to get. Is it clear or not? So guys, basically, this particular question was asked to the Supreme Court, that what should be done. So much of power with the PMLA, is it constitutionally valid? So much power with the ED, is it constitutionally valid or not? So basically, guys, there was one particular question, that is the question of the twin test. question of the twin test condition for bail. What is this twin test? Twin test means that if a person has been arrested under the PMLA, then before granting him the bail, there are the two conditions which are to be fulfilled. Condition number one, that a person should convince to the court that he is innocent. He is innocent, the court should be convinced. And second, while he will be on the bail, he'll not commit any crime. He'll not be committing any crime. When these two conditions will be fulfilled, then only the bail can be given. So this was the twin test condition under the PMLA that was there. Now this particular condition was removed in 2018 in one another judgment, that was the Nikesh Tarachand judgment. This condition was removed. But what happened in this Vijay Madan Lal Chaudhary case? In this Vijay Madan Lal Chaudhary case, this twin test condition was again revived. This twin test condition was again revived. And in Satyendra Kumar Antil case also, the Supreme Court has provided that we need to give more and more number of bail. That was something that was provided. So guys, basically all these things have happened by which the bail again and again is coming in the news. So that is all the background. This background is not though given in this particular article, though not given, but guys, you need to know all these particular background in order to understand these kind of issues much more in the detail. So let's now go in this particular article, and now let's understand the article. So basically guys, this article is coming on the bail only. So basically the article says that when we talk about the bail procedure in India, it is the bedrock of the article number 21 of the Indian Constitution. Now what is article number 21? Article number 21 is about the right to life and personal liberty. Now article 21 provides that a person's liberty can only be taken, a person's liberty can only be deprived when there is a law in that particular direction. And not only the law needs to be there, rather the law needs to be fair, law needs to be just. So a person's liberty can only be taken when there is a procedure established by law, and law needs to be just, fair, reasonable. Now guys, basically whenever a person is arrested, for that particular person, the bail has been provided into the Criminal Procedure Code, CRPC. So there is number one, the section 438. Now the section 438 allows that a person can approach the court in advance. The person can approach the court in advance and can ask a bail. Okay, can ask a bail, can ask an anticipatory bail, that if in case he gets arrested, that then he will come out on the bail that he has already taken in advance. So guys, let's say that sometimes there is a particular person, on that particular person, let's say an FIR has been filed, and now this particular person suspects that he might be arrested in 1 or 2 days by the police. So therefore he can approach the court under the section 438 of CRPC, section 438 of CRPC, and can secure a bail. That is one bail. Okay, and then there is one more type of a bail that is provided in section 167 of CRPC. This is called as a statutory bail. Statutory bail. What is a statutory bail? Let's say guys that a person got arrested, and the investigation is going on in this particular person, that whether he had done that crime or not. If investigation is not completed within the scope of 60 or 90 days, now it depends on to the severity of crime. If a crime is very much severe, 90 days. If crime is less severe, 60 days. So if the investigation is not completed within the 60 or 90 days, then by using the section 167, he can ask for a statutory bail, which means that, okay, now a lot of time I have spent into the jail, give me a bail. Okay, so by section 167, section 438 of the CRPC, the bail can be secured from the court. That is something that is there. Now guys, when the bail is secured, at that point of a time, the court needs to follow one golden principle of natural justice. One golden principle of natural justice. What is that principle? Principle is that the presumption of innocence is foundational postulate. Presumption of innocence is foundational postulate. It means that a person is believed to be innocent until and unless the person is proved to be guilty. So innocence will be presumed, and by presuming that particular innocence, everybody is to be seen in a kind of a humane light, and therefore a person is to be given a bail. So that is the issue that's going on. However, there are some kind of a laws under which giving a bail is a very difficult kind of a condition, and the nature of the law provides that particular thing. I'll give you certain examples. For example, there is the Unlawful Activities Prevention Act. Unlawful Activities Prevention Act. Under the Unlawful Activities Prevention Act, the people can be charged if they have done some anti-state activities. Okay, then there is a Narcotics and Psychotropic Substances Act, where the people trading in drugs, possessing the drugs, can be arrested. Then the Prevention of Money Laundering Act. In this particular condition, there are very strict conditions for the bail. And for this Prevention of Money Laundering Act, okay, so for this Prevention of Money Laundering Act, even I have discussed with you this twin test condition for the PMLA. So there is a very difficult condition. Okay, so this is the thing. However, guys, in other cases, the bail is given with a very the giving a bail is a very normal kind of a thing. Now understand this particular thing, that actually the society, it has developed a kind of a wrong notion as when the people are arrested. Society thinks that the jail is to be given. Jail is a necessary consequence of an arrest. If a person has been arrested, guys, understand that if a person is being arrested, then after doing some interrogation, after doing some question, that particular person can be released. Okay, so arrest doesn't necessarily means then that a person will be put into a jail only. But society thinks, the people thinks that arrest will necessarily lead to the jail, and if there is failure of a jail, then that particular person might come and endanger the society. But understand this particular thing, that guys, sometimes when a person is just being put into the jail, for so long time he is staying into the jail, even when his crime is not proved, what happens? The process itself becomes the punishment. What happens? Okay, what happens? I'll again highlight the process itself becomes the punishment. Okay, so basically this was a process, it became a punishment. Now in this particular capacity, guys, there are some very good judgments that have been given by the Supreme Court, and all the judgments are focusing on this particular thing. You should give bail as a kind of a routine, and if the bail is being denied, there needs to be some very extraordinary kind of reasons. So number one, the Sanjay Chandra versus CBI 2011 case. In the Sanjay Chandra case, it was provided that the grant or denial of the bail is to be regulated by the circumstances and the facts of each case. It has been provided that the bail is not to be denied because of the sentiments of the community against the accused will be hurt. Now guys, sometimes the cases becomes very much media sensitive, sometimes cases becomes the politically sensitive. Now guys, let's understand this particular thing. What happened few months back, the son of a Bollywood celebrity got arrested, and it was said that he had possessed some of the drugs. Then what happened? The media trial went, and the media became the judge, the jury, the executioner. Please use these words. What happened? Media became the judge, the jury, the executioner, and media declared that yes, that boy is guilty. And in that particular thing, guys, the public sentiments turned against that particular boy. Everybody was criticizing the Bollywood, everybody was criticizing the celebrities, even without knowing that what were the facts of that particular case. Now though, what happened? Public sentiments were very much negative. Now here the bail needs to be just considered on the basis of fact, not on the basis of sentiments. But what happens? Many a times the judges also get influenced by the sentiments and they deny the bail. Then guys, there was one more in 2022, the Supreme Court has provided one very important judgment. Supreme Court has provided that reasoning is the lifeblood of the judicial system. Whenever the Supreme Court or any judge and any court is giving any kind of a justice, any kind of a judgment, they need to give the logic, they need to give the reason that why we have given this particular judgment. Now what has happened many a times the judges deny the bail, but they don't give any kind of a sound reasoning that why they have denied the bail. So this is something which should not happen. Then guys, understand this particular thing, that when we talk about the grant of the bail, in that particular thing, there is one triple test condition also that is there. This is different than that particular twin test. Okay, triple test, it is a very general condition. It means that when the bail is being given, generally what a court or what a judge will consider. So generally, basically, it will be considered that whether there is the risk of a flight, the person who has been arrested, whether he'll run away. If he will run away, he will not be given a bail. But if he'll not run away, he'll be given a bail. Then the possibility of tampering the evidence. If he is released, will he go and will destroy the evidence? And the third is influencing the witness, if the person will influence the witness or not. So under these three conditions, the bail is decided. But many times what what happens? Basically a lot of subjective assessment is being done. Now guys, understand this particular thing. There is one more judgment of Supreme Court, that is the Chidambaram case of 2019. In the Chidambaram case, the Supreme Court provided this particular thing, that the gravity of offense is also an additional condition to determine whether the bail is to be given or not. So basically these are the 4 conditions under which the bail is determined, but many number of times the judges are denying the bail but are not giving the very clear reasons that why the bail is being denied. So by that particular thing, what happened? The jurisprudence of bail is getting impacted, and by that particular thing, what is happening? People's right to liberty is getting impacted. Article number 21 of the Indian Constitution is getting violated, and by that particular thing, there are many of the multiple issues that are coming in this particular direction. Okay, and guys, therefore now you connect the, okay, now in a reverse manner we'll be connecting this particular thing. So what happened? Because of this thing, Satyendra Kumar Antil versus CBI judgment came, and in the Satyendra Kumar Antil judgment, CBI the Supreme Court provided that we need to have a kind of a bail law, so that people are not just being denied a bail on any flimsy kind of grounds. Now guys, this happens to be a very important topic for our GS paper number 2, criminal justice system reforms. Very important article, and I think and I believe that even a full length question on this particular thing will come in your GS paper number 2. So that's all about this article, and now we'll move to the next article, explaining Pakistan's flip-flop on trade with Pakistan. Explaining Pakistan's flip-flop on trade with India. So basically guys, what has happened right now, we see this thing that in Pakistan there is a flood going on. Okay, and in that particular direction, okay, the finance minister of the Pakistan has indicated that now they want to do trade with India. Okay, so on that particular direction, this particular article has come. By the way, this article will be important in GS paper number 2, relations with neighbors. Okay, and in that India-Pakistan relations, we'll see this article. Now, what has happened? The Pakistan's finance minister has announced that the Pakistan's Economic Coordination Committee, they had decided that they'll import from India the cotton, yarn, and the sugar. Now understand that what has happened in Pakistan, there is flooding that has come. Because of the flooding, the standing crops in the Pakistan got destroyed, the plantations of the sugarcane got destroyed, the cotton got destroyed, and because of that particular thing, there's a lot of shortage of these basic commodities that have come in the Pakistan. Moreover guys, right now the Pakistan is also facing a high inflation, and in that capacity, if these prices go up, then there will be a lot of human sufferings in the Pakistan. So therefore Pakistan now want to go forward and want to resume the trade with the India. Now understand guys, in the past, basically this equation of trade between the India and Pakistan got little bit changed. Why? Because in 2019, what happened? The article number 370 of the Indian Constitution got diluted, and the special status that was given to the Jammu and Kashmir, that special status was rolled back. Now the Pakistan has a problem with this particular thing. Pakistan said this thing that the status that of the Jammu and Kashmir that got changed, it was basically, according to Pakistan, it was arbitrary. Pakistan says that India should have consulted with Pakistan. Okay, so therefore Pakistan doesn't understand that these are the internal matters of India. Okay, and the Pakistan, there is no business of Pakistan in this particular thing. But anyhow, the Pakistan protested against the India, and since then the economic trade relations between the India and Pakistan, they came very much low. Now basically Pakistan again wants to start the trade because of this flooding that has happened in the Pakistan. Now guys, understand this particular thing, that basically what has happened, there is one very big problem in the South Asia. The problem is that there is a supremacy of politics over the trade and economy. Now Pakistan is very much dependent on India in terms of sugar, in terms of cotton, in terms of textile, but even knowing this particular thing, Pakistan snaps the trade relation with the India because of the domestic politics, because of the anti-Indian sentiments that often come in the Pakistan. So guys, this is something that is there. The Pakistan knows this particular thing, that basically if Pakistan will go for the imports from the India, it is beneficial to the importing country, it is beneficial to the Pakistan only. But still the Pakistan places politics above. This particular thing that say that this particular thing shows that the business community and the export potential has become secondary. The political interest has become primary. And this failure is not in the Pakistan. This failure is in the most of the countries of the South Asia. Guys, understand this particular thing that when we talk about the South Asian countries, we have the SAARC, that is the South Asian Association for Regional Cooperation, now SAARC. Now guys, when the SAARC members are considered, within the SAARC, the trade, the economic cooperation has been very much less. Why the trade and economic cooperation has been very much less in the SAARC? It is because of the fact that the confidence between the countries is not there. They are not considering the business interest, rather the domestic politics and all these things have become very much important within the SAARC members. Now guys, this is the reason that the SAARC has not been able to scale the economic potential as other unions have been able to do that particular thing. Moreover guys, when we talk about the SAARC, for so many of the years, we see this particular thing that the summit even had not happened in the SAARC. Now why the SAARC summit has not happened? Now basically for so many of the years the SAARC summit has not been happened. Now what's the reason for this particular thing? The reason is this, that actually India and Pakistan, they are not having the good relations, and because of the India-Pakistan bad patch that is going on, what happened? There were the Uri attacks that were carried, and into the Uri attacks, the Pakistan had played an important role, played a role. So basically, India condemned Pakistan, and therefore within the SAARC also, the meets have not been held. Now, in this particular capacity, we have seen that the SAARC has been struck. Okay, and therefore basically the trade relations are getting impacted. So basically all the countries in the South Asia, they need to understand this particular thing, that they need to come out of this particular hangover and need to understand that the business interest, economic interest are more important than the political interest. So that's all about this particular article, and now we'll move to the next article. Tribe categorization work delays benefits under the SEED. This article will see with respect to GS paper number 2, social justice and the vulnerable sections of Indian society. Social justice and the vulnerable sections of Indian society. Okay, now let's discuss this article. So basically guys, this article, it's just a one-liner concept in this article, but to understand that one-line concept, you need to know some of a background, because if we don't know this background, we will not be able to understand that what this article is trying to say. So basically guys, let's discuss the background. And the background information I had provided you here in these notes only, so that you can read it after this video also. So what happened? Basically, there is a scheme, that is the SEED scheme. Okay, the SEED scheme. Okay, now guys, the Ministry of Social Justice and Empowerment has launched this particular scheme, that is the SEED scheme. Now what's this SEED scheme? It stands for, just a minute, it stands for the Scheme for Economic Empowerment of Denotified Tribes, for the welfare, the Scheme for Economic Empowerment of DNTs, that is the denotified tribes, nomadic tribes and the semi-nomadic tribes, SEED scheme. Under this particular SEED scheme, the denotified, semi-nomadic and nomadic tribes will be given the benefits, educational benefit, health benefit, all these benefits will be provided. For example guys, under this particular thing, free coaching will be provided to the students, so that they can go for the competitive examination, so that they can prepare for the civil services, so that they can prepare for the professional courses, such as the courses of the medicine, engineering, MBA. So guys, for the CAT, for the NEET, for the IITs, all these particular professional exams, competitive exams such as the UPSC CSE, the free coaching will be provided. One. Then the next is that under this particular SEED scheme, the health insurance will be provided. So we have the Pradhan Mantri Jan Arogya Yojana. Okay, there is a National Health Authority. So the National Health Authority runs the Pradhan Mantri Jan Arogya Yojana. So under that, they can avail the health benefit, health insurances. And then there is the livelihood support will be provided, income generation support will be provided, and housing will be provided. For the housing, we have the Pradhan Mantri Awas Yojana. Pradhan Mantri Awas Yojana. So all these benefits will be provided under this particular scheme, that is the seed scheme. The seed scheme. Now understand this particular thing. The seed scheme, it is applicable on whom? It will be applicable on denotified tribes, nomadic tribes, and the semi-nomadic communities. Now, what are these communities? Number one, the denotified tribes. Denotified tribes. So basically, guys, there is a little bit history behind this particular thing. What happened? The Britishers have considered that certain tribes, they are the criminal tribes. They basically, certain tribes were declared as a criminal tribes. Okay, and guys, in these particular tribes, even when a child was born, a FIR was to be registered into the nearby police station that a criminal has been born. So certain tribes were given the status of a criminal tribe, and for that particular thing, Britishers have one particular act also, that is the CTA Act, that is the Criminal Tribes Act. And under that particular thing, the police people, they need to maintain a log about the movement of these people, about the activities of these people, about the occupation of these people. So this is something kind of a discrimination that the British have done. They have categorized certain people as a criminal tribes. Okay, now that is going on. Now what happened when we got independence after the 1947, government removed this particular issue and denotified those particular tribes. Understand, the tribes which earlier got notified as criminal tribes, now these tribes are to be denotified. Okay, so these people who were earlier the criminal tribes, now they are called as the denotified tribes. These people are now called as denotified tribes. Now guys, you can read this particular thing also. I have written here in this handout that denotified tribes stand for all the communities which were once notified under the Criminal Tribe Act enforced by the British between 1871 to 1947. Then guys, this particular act got repealed. This act was repealed by the Indian government in 1952, and then they got denotified. Now basically what happened, these particular tribes, they were ignored, they were discriminated, and a lot of injustice happened with these people was done by these to these people by the Britishers when they were considered as criminals. So therefore, for their welfare, now we come out with some kind of a special schemes, special mechanisms. Okay, then guys, there are the nomadic communities. Now when we talk about the nomadic communities, these communities are also called, are sometimes referred to as the Banjara communities. Banjara communities means the communities which don't settle at one particular place, and they will roam from one place to another place in search of livelihood, in search of food, etc. So these were the nomadic tribes. Okay, now guys, today they don't much of them, they got settled, but these were their historical patterns. So basically, nomadic tribes, they have a distinct culture, political, social lifestyles, customs, traditions. Okay, now this is something that is there. Now guys, who are the people who come into these particular tribes? So basically, the people involved into the key making trade, salt trading, entertaining, they do acrobats, dancers, they are the snake charmers, jugglers, okay, pastoralists. Okay, all these people will come in this particular category, and for their welfare. Now these people happen to be poor compared to the other people of the society. Okay, so therefore basically guys, these people, all these people are to be given the benefit under this particular seed act that was announced by the Ministry of Social Justice. So this is something that is going on. So this is first of all the entire background of this particular article. Okay, now basically what happened, this particular the implementation of this particular act is getting delayed. The implementation of this particular act is getting delayed. What's the issue? So basically, once government announced this particular scheme, government found that there are actually 1400 communities and approximately 10 crore people who will come under this particular scheme. These 10 crore people and these 1400 communities are ones who will get the benefit under that. Now guys, these 1400 communities, now they are to be categorized as scheduled caste, scheduled tribes, OBCs. Understand this particular thing, guys, no need to be confused. Denotified tribe simply means that earlier who were criminal tribes, now they got denotified. These are the denotified. But once they have become denotified होने के बाद में, where they are going to become? Will they become SCs? Will they become STs? Will they become OBCs? This is another question. Nomadic tribes, within the nomadic tribes there are many people. Now these nomadic, some of them will become the scheduled caste, some of them will become scheduled tribes, some of them will become OBCs. So in total, these 1400 different communities within these nomadic, semi-nomadic and denotified are there, and these 1400 communities are either to be put in the SC, in the ST or in the OBC list. Now for that particular thing, guys, government is doing the survey, and in that particular capacity the work has not been done up till now. So basically, first guys, please focus on this particular screen. So here we can see that the more than 10 crore Indians from 1400 communities belong to these groups. Now the issue is that these 14 communities, now they be put in SC, ST or the OBC categories, and this particular thing is holding up the implementation of this particular scheme. So this is something that issue has come in between, and because of the procedural issues, because of the implementational issue, the scheme has not been properly be rolled out to the people. So this is guys the entire issue of this particular article. So again I am telling you this particular thing, that this background, okay, this entire background is very important. You getting it or not? So that's all about this. Please download the PDF and follow it. Now we'll move to the next article. Okay, so guys, here there are the 3 articles that have been featured in the different pages of the Hindu newspaper. The first, I'll read the heading: violent crimes in country back to pre-COVID levels. Delhi is the most unsafe metro for the women, and again violent crimes back to pre-pandemic level. So basically guys, now just understand this particular thing. For GS paper number 2, law and order, GS paper number 2, law and order. Basically, when the crime is concerned, in for that particular thing, National Crime Record Bureau releases its report, okay, and under this particular report, NCRB provides the data as how many number of cases have been filed in the last year, how many of the FIRs have been filed into the last year, and on that particular basis the National Crime Record Bureau gives the crime trends. It gives the crime trends. Now guys, what has happened? Basically, once the pandemic got started, during the pandemic the violent crimes came little bit down. Why the violent crimes came? Because there was a lockdown, people were struck into their houses, and by that particular thing some types of crimes got reduced. And now the NCRB's report, that is the report of crime in India, it provides that the violent crimes are now again increasing, and now the intensity and the numbers of the violent crimes, it is reaching the pre-pandemic levels, that is around the level of 2019. So basically the report, what it provides. Now guys, understand, before going in this particular article, one thing to note. Now see, basically this report is telling the data, for example the rape. Now the number of rape in 2019, the number of rape in 2020, the number of rape then in 2021. You will not be able to remember the data, that how many thousand, how many hundreds of cases came. You will not be able to remember the data. So therefore no need to go and remember the data. Moreover guys, the data with respect to the different states, different union territories have also been given, that what's the trend in Punjab, what's the trend in Delhi, what's the trend in Haryana. So no need to go in numbers, no need to go in the data, just will be seeing the broad highlights, okay. Now number 1, the NCRB report provides this particular thing, that the violent crimes. Now what crimes will come into the category of violent crimes? Rape, kidnapping, atrocities against children, atrocities against women, then the robberies. Fine, they have increased in 2021 after the pandemic related restrictions came to the decline. This is something that has been provided. Fine, now guys, in this particular capacity it has been provided that the crime rate per 1 lakh people actually got decreased. Now listen this particular thing, violent crimes increased, but the crime per lakh got decreased. Now what's the reason why this particular thing is happening? Because guys, when the COVID-19 pandemic was going on in 2020, large number of cases were filed under the section 188 of IPC. What was the section 188 of IPC? Basically guys, many times people were not wearing the mask, many times people were not doing the social distancing, so many number of people were filed under the section 188, that is the disobedience of a public servant. So mask violations, social distancing violation, crowd gathering violations, many of the cases were filed. So therefore in 2020 many such number of cases were there. These cases now have come down because guys, many of these COVID-19 restrictions are now getting minimized. So therefore crime per lakh got increased during 2020 because of the people who were being arrested, being charged under the mask violation, social distancing violation. But the violent crimes are now again increasing, and at per and they have been rise coming or going on rise, and they are near the pre-pandemic level. Is it clear or not? So basically guys, you see this particular thing 2019, 2020 and 2021. So basically the robbery, fine, the kidnapping, the robbery, the crime against the children, the kidnapping, rape, murders, they have again reached to that particular thing. Okay, now guys, here the absolute numbers that have been given, fine, no need to remember that. Okay, no need to remember these particular numbers and these particular datas that have been given. Okay, you will not be able to retain that. Now when we talk about the women, basically Delhi is one of the most unsafe metro for the women. Now the crime against children, crime against women, crime against elderly, cyber crimes, all have been on increase. Now first of all, when we talk about the crime against women, the crime against women has increased even the pre-pandemic level. So this is something that has happened. Okay, so guys, please remember the report. Now basically the crimes that are increasing crime also means that the reporting by the people has increased. Now why the reporting by people increase? Because many number of times people are becoming more educated with the coming of the education, with the coming of the social media, with the knowing of their rights. All these particular things are there. So that's all about this article, and now we'll move to the next article. Minority status plea, government seeks time. This article will see with respect to GS paper number 2 polity. Okay, now guys, understand this particular thing, that when we talk about minorities, there could be the linguistic minorities, that is onto the basis of language, and then there could be the religious minorities, that is the minorities onto the basis of religion. Now understand this particular thing guys, that when we talk about India, in India on pan India level, for example Hindus are majority, but at the same time there are certain areas, fine, there are certain states where Hindus are still the minority. Is it clear or not? For example guys, there is the Jammu and Kashmir, then there is other Andaman and Nicobar Island. Okay, so basically there are the minorities. Now from the past few months, there is one particular question that is going on. The question is that who has the power to declare the minority status? Can the center give the minority status, or can the states give the minority status? So who has the power of giving minority status? In that particular capacity guys, recently what happened, the Ministry of Minority Affairs basically published its affidavit into the Supreme Court and provided that actually both the center and the states, they have the concurrent power. That means both can give the minority status to some of the communities. Now why this particular question was coming, by the way, I told you guys that there are the Hindus who are numerically very much less in the 10 of the states. Are you getting it or not? They are numerically less in the 10 of the states, and they were asking in these 10 states the minority status. They were asking the minority status in these 10 states. Now the state governments wanted to give the minority status to Hindus, but the question came that whether the state government has power to give the minority status or not. So number one, the Ministry of Minority Affairs said that both the center and the states have the concurrent power. So it simply means that they can notify the minorities, not at all a problem. But then what happened, the Ministry of Minority Affairs made a kind of a U-turn, and Ministry of Minority Affairs provided this particular thing, that the center alone was vested with the power to notify the minority community. The states don't have any power to notify the minority community. It simply means that the state governments, if they want, they cannot give the minority status even to the Hindus in their own state. Now Supreme Court is asking a question from the Minority Affairs Ministry, that you first of all be clear, what do you want to say? Can the states give the minority status or not? Okay, fine, what you are trying to say? Fine. So in this particular capacity, now the government had said that we want more time. So government seeks more time. Government had said that okay, we got confused, let us decide, give us more time, and after a few weeks or few months time, we'll tell that who has the final power to give the minority status. Is it clear? So this is this entire issue that has come. Nothing more than that, nothing less than that. Okay, so guys, this is the entire issue, and basically we'll see in the coming days that what finally will be done, and whatever will final decision be coming, will update our notes again. So that's all about it, and now let's move to the next article. Curing the patriarchal mindset of the legal system. Now this particular article will see with respect to GS2. GS paper number 2, judicial reforms, as well as in GS paper number 2, women related issues, this article will also be seen. Now let's see this article. So basically, this article talks about that how the patriarchal mindset is prevailing in the law curriculum, and how the patriarchal mindset into the law curriculum is impacting, it's bringing many of the challenges. Now, first of all, I'll give you a little bit of a background as what happened and why this particular article is coming in the news. So basically, guys, recently one of a session court in the Kerala, it was hearing one particular case. Now the case was that the women said that basically there is a person who had just a minute. Yes, so basically what happened, there was the women who charged a particular person for the sexual harassment. Okay, he charged a person for a sexual harassment. He said that that person had carried the sexual harassment. So the case was going on under the section 354A. At that point of a time, the judge provided this particular thing, that section 354A will not be applicable if the woman was wearing a sexually provocative dress. Okay, so basically what happened, section 354A, again I'll explain. Section 354A, a person can be charged for the sexual harassment. Fine, the women filed a case against a person. The judge says that the section 354A will not be applicable if the woman is wearing a sexual provocative dress. Now there are two questions that arise in this particular thing. Question number 1, that what is a definition of the sexually provocative dress? Okay, now even a girl wearing a jeans might be sexually provocative to a one person, but might not be to another person. And actually, who has given the power to anyone to give the certificate that this dress is sexually provocative, this dress is not sexually provocative? At the end of the day, it is the right of a woman that whatever she wants, she can wear that particular thing. So this particular kind of a comment of calling a dress as a sexually provocative dress, such things shows that there is still a kind of a patriarchal mindset even in the members of judiciary, and such patriarchal mindsets are needed to be reformed. That is something which is being provided. Now guys, basically this particular thing has been called as a patriarchal, or this particular thing has also been called as the Freudian slip. This thing has been called as Freudian slip. Now what is the concept of this particular Freudian slip? Now the Freudian slip, it means that sometimes there is an error in speech, sometimes there is an error in speech, memory or action because of some unconscious subdued wish or internal train of thought. Now guys, understand this particular thing, that suppose there is a person, Mr. X. Now Mr. X, at the back of this particular person's mind, this particular person believes in the caste. This particular person believes in the caste superiority, that certain castes are superior. Now let's say that at one of an instance he gave certain comment where he had affirmed this particular caste superiority. Basically what happened, in deep down his thought, deep down his memory, that caste superiority was very much embedded, and now it has come to the fore. So basically it is being provided that even the judge who had given this particular statement that if a woman is wearing the sexual provocative dress, that case their section 354A will not apply. It means that deep down there was a kind of a toxic masculinity that was there, and now that particular thing got manifested. It is called as the Freudian slip. Okay, then moving on, basically it has been provided, guys, that saying that some of the women's dresses is a sexual provocative dress, it is nothing but the objectification of women. Now guys, it has been provided that such comments by the judges, it doesn't impacts only the one person, it doesn't impacts only that particular women, but it impacts the entire socio-legal system. Now guys, if the judges will give such kind of a comment, what the other people will be learning? Okay, what society will learn from this particular thing? This is something that is there. Now it is violation, it is affront, it is violation to women's constitutional right, to the right of their dignity, right of their personal liberty, right of their privacy. See, it is their own personal matter, it is the matter of their privacy, what they want to wear. So judge did not had any authority to pass the comment on the matters of her own privacy. Fine, that is the matter of her own personal choice, what is to be worn and what is not to be worn. Now understand this particular thing, that guys, basically there have been some of the Supreme Court judges judgments also in this particular direction. So there is the Aparna Bhatt versus State of Madhya Pradesh judgment. In this Aparna Bhatt versus State of Madhya Pradesh judgment, Supreme Court provided this particular thing, that the use of reasoning or the language, such kind of language which diminishes the offense and tends to trivialize the survivor, it is to be avoided. Now guys, what happens? Sometimes the survivors, let's say the women, they are trivialized. For example, suppose a person had made an oral remark towards that women, and let's say women files a case in that particular thing. Now sometimes the women will be trivialized, that okay, why you are making an unnecessary fuss, it's not a big thing, okay, you are just making a issue out of that. So what has happened? The women are being trivialized, women are being basically, they are being trivialized. Now such kind of a language, such kind of an actions are to be avoided. Now the same thing has happened in this particular case, where the judge made a comment that the women was wearing a provocative dress. What happened? The women got trivialized. So this particular thing should not be done, as provided by the Supreme Court in Aparna Bhatt versus State of Madhya Pradesh case. Moreover, understand this particular thing, guys, that this particular instance is also the clear violation of the guidelines given by the Supreme Court, as already we have discussed here. Moreover, one of a very notable author, Geeta Hariharan has written in her book, the name of the book is Listen to My Case. She points that particular thing, that women in India find there is very much hard for a woman to going to the court. Why? Because number one, women many number of times are not getting any kind of a support. Fine, they don't have any financial support, they don't have any emotional support, they don't have any support from the family, even the customs, okay, and the present laws that are there, they are very much biased against the male, so in that particular capacity, it is being said that the women, they don't have any protection, so therefore going to the court becomes very much a difficult thing for them. This is something. Moreover, the representation of women in the Indian judiciary is very much low. Now guys, in this particular capacity, if I give you the data, in the lower level judiciary, 30% of the judges are the women. Okay, I'll just write the data. You can note down this particular data in your notebook. So in the lower level judiciary, there are the 30% women judges. In the High Court, there are 11.5% of the women judges, and in the Supreme Court, nearly 12% of the judges are the women judges. So if we see in the lower level judiciary, still the representation of women is fine, but into the High Court, Supreme Court, the representation of women is very much low. So because of the low representation of the women, okay, and even 30% is not something which is acceptable. So basically the women, they don't have a confidence that they can approach the court and their cases will be heard with empathy, their cases will be heard with the compassion. This is some issue. Now guys, understand this particular thing, that there is actually some of the judgments which have been very much regressive. For example, there was a Bradwell versus state of the state of Illinois judgment. This judgment was given by the Supreme Court of the USA. Now this judgment was given in 1872. In this particular judgment, what happened? One of a women, Myra Bradwell, she wanted to pursue the legal education. But at that point of a time, women were not allowed to pursue the legal education. So she applied for her case, and in that particular case, that is the Bradwell versus State of Illinois, the Supreme Court, US Supreme Court said that the God designed the sexes to occupy different spheres of action, and it belonged to men to make, apply and execute laws. Now this is something very regressive judgment that is being given. What happened? The Supreme Court of the USA genderized the rules. US Supreme Court said that the male will make the law, and women, what they need to do, it provided that the women, they need to fulfill the noble and benign offices of wife and mother. They should be just wife and mother. This is the role of the women. So this is something which was said by the US Supreme Court. Now these kind of judgments show this particular thing, that how the sensitivity with respect to the genders, it is missing even in the judiciary. So therefore there is some need of the hour, some reforms that are to be carried. What are the reforms? Number one reform is that in the legal education, there needs to be the inclusion of the feminist jurisprudence in the curriculum of the law. The sensitization of the legal practitioners, lawyers, etc. is to be done, so that they understand about the feminine thought. Now first of all, understand this particular thing. What do you mean by feminism? So guys, word feminism never means that some special treatment is to be given to the women. Feminism simply means that the male and the female are needed to be treated equally. So feminist thought, feminist thought, feminine theories, how the equality of sexes is important part of the Indian society. These things are needed to be taught into the legal education. Fine, because once they are getting the legal education, after that they'll become advocates, after that they will become lawyers. So in the legal education, the curriculum is needed to be changed, and the feminist jurisprudence, fine, feminist thought, sex equality, all these things are needed to be taught. Then next thing is being provided that feminist legal philosophy is an effort to examine and reformulate the legal doctrines. Okay, the bias that is there into the legal practice, in the biases into the judges, advocates, it can be only be removed by bringing this curriculum change. Now guys, here there is one very good quotation that has been given by the J.S. Mill. So you can note down this particular quotation directly in your notebooks, or you can download this PDF. What the J.S. Mill said? J.S. Mill said that the choice of dress is a self-regarding act over which the individual is a sovereign. Self-regarding act. Now see, what does it means? Now guys, according to J.S. Mill, there are two types of act: self-regarding act and the others regarding act. Self-regarding act and others regarding act. Okay, self-regarding act means certain actions which will impact me only. Then others regarding act means certain actions which will impact other people also. Now it has been provided by the J.S. Mill that when the self-regarding actions are there, self-regarding actions are not need to be controlled. There a person has an absolute liberty. There the J.S. Mill said that the individual is a sovereign. Now wearing any kind of a dress, it is a self-regarding action. It is not going to impact others. So in that I need to be complete decision making authority. So this is something that's been provided here. So that's all guys about this particular article. I hope you have understood. A very good article with respect to the gender issues. Find the gender issues in the legal sphere, a very good issue. Fine. Now that's all. We'll move to the next article. Challenges of subnational fiscal correction. Challenges of subnational fiscal correction. Now this particular article will see with respect to GS paper number 2. Issues of fiscal federalism. Issues of fiscal federalism. Also will see with respect to the GS paper number 3. Okay. The financial issues between the center and the state. So GS2, GS3, both places in this article will be important. Now guys, understand this particular thing, that when we talk about India, just a minute. Okay. So right now, there are many challenges of fiscal federalism that are emerging in India. Now understand this particular thing, that guys, when we talk about India, in India, the financial powers, they are divided into the domain of both the center as well as the state. There are many areas where the center has been given the power that they can carry the expenditures. They have also been given the power to raise the taxations. Large number of powers were there with respect to the raising of the taxations before the coming of the GST. In indirect taxes, many of such areas were there. However, after the coming of the GST, many of the powers of the state government into the matters of the indirect taxes, it got subsumed within the GST. Okay, so guys, when we talk about fiscal federalism, simply fiscal federalism means that in India, we have the center and we have the state. Both have their own financial power with respect to the raising of the financial resource, and the powers in terms to decide where to spend the money, where to do the expenditure, where not to do the expenditure. So the fiscal federalism is there in the Indian constitution. Now understand this particular thing, guys, that when we talk about the government, union government and the state government, they are expected to work very closely in the cooperative federal structure. So we have the cooperative federal structure. Now they have to work in cooperation. Now why they need to work in cooperation, I need to tell you certain number of things. Basically guys, number one, there is a finance commission under article number 280. Now the finance commission recommends the transfer of the money from the center to the state. Guys, before the 14th finance commission was there, 32% of the taxation money that was raised by the center, it was to be given to the states. And after the 14th finance commission, the 14th finance commission suggested that the 42% of the taxation that is being raised by the center, 42% money is to be going to the state government. Then the 15th finance commission, which is the present finance commission, 15th finance commission now has given the suggestion that the 41% of the finances that are being raised by the center government, the 41% should go to the state government. So basically, whatever the money is being collected by the center government by the way of the taxations, this a substantial portion is going to the states. So this is an example that the cooperation cooperation on fiscal front is going on between the center and the state. Number two, guys, what happens, there are many of the grants also that are given by the center to the state government. In the GST also, what is happening, the GST money is being collected by the center government, but that GST's money's share is going to the state government in their proportion. So the cooperation is needed. Then guys, then there are many of the central sponsored schemes. There are many of the, just a minute, then there are many of the central sector schemes, and then there are the center sponsored schemes. Okay, now what do we mean by, first of all, the difference between the central sector schemes and centrally sponsored schemes? Central sector schemes are those schemes where the entire money will be given by the center government. Only the scheme is to be implemented by the state government. And then there are the centrally sponsored scheme. In centrally sponsored scheme, there will be certain part of the money that will be given by the center government and some part of the money that will be given by the state government. Now the ratio depends on that particular state. For example, for different states, the ratio could be 60 to 40. The hilly states, the ratio could be 90s to 10. 90s to 10 means 90% will be given by center, 10% will be given by the state. So there are the different ratios. So central sponsored, both the center and the state will bring money and they will use that money. Central sector states, central sector schemes, only the money will be given by center. The state government is going to implement that particular scheme. So basically, guys, all these particular examples that I had given you here, it simply shows that on the financial arenas, both center and state are coming together, and by coordination, by cooperation only they need to work. So basically, cooperative fiscal federalism is a very important part of the Indian constitution. Now guys, understand this particular thing, that all these particular examples that I had given, very important article, though many of them are not provided in this particular article, but please, I'll say, note down these particular examples in your notebooks. Okay, now coming back, so basically it has been provided that there are the cooperations that are needed to be done, but into the recent times there have been the issues where many of the challenges are coming. Now first of all, at the goods and the service tax, GST. Now in the GST there are many of the disputes between the center and the state, and the disputes are there. For example, what needs to be the rate structure, now guys, we have the different GST rates. Okay, we have the tax slab of 18%, we have the tax slab of 28%, 5%, 12%. There are different tax slabs. Exclusion of commodities, which will be coming in GST, which commodity on which commodity GST will not be applied. Fine. Revenue sharing. Okay, how much revenue will be shared with the state government? All these issues are there in the GST on which the disputes are coming. Then guys, state level expenditure patterns, especially related to the welfare schemes. Okay, now guys, many of the state are running the welfare schemes. Okay, in welfare schemes, many such entitlements are being provided by the state government. For example, Mamta scheme is being run into the Odisha, where entitlements are being provided to the mother and the child. Many such state level welfare schemes are there. So how much money is to be spent by the state, and in which direction the money is to be spent by the state? Okay, this is one issue. Implementation of central schemes. So basically, many number of times it is being said that the proper implementation of central schemes is not being done by the state. Why? Because simply center government is giving the 100% money. Now guys, understand this particular thing, that when we talk about the issues of the GST, okay, there is a GST council meetings. In the GST council meetings, both the representatives of the central government and the state government can come together and they can discuss this particular matters. But guys, what has happened? Okay, but what has happened? Into the GST council, often and again this particular thing has been seen, that the matters that are very much important to the center and the state, these matters are not being aptly discussed. Now understand this particular thing, that there is also one more matter, that a matter is of the discretionary expenditure. Now guys, understand this particular thing, that when we talk about the expenditure that is to be done by the state government, there are two type of expenditures. One is the mandatory expenditure and other is a discretionary expenditure. Now the mandatory expenditure is that money which has to be be spent anyhow. This particular money, it is governed by certain formulas or certain criteria. Now guys, mandatory spending, for example, some minimum money has to spend in law and order, some minimum money has to be spent in, for example, for paying of the salaries, etc. So there are some mandatory spending that government has to spend in order to survive. Then there is a discretionary spending. Now guys, discretionary spending is that which government will be spending on to the need basis. For example, right now the pandemic of COVID-19 is going on. In this pandemic, the economy got suffered a lot, and as the economy got suffered, the government comes and gives the fiscal stimulus. It provides some additional support to the economy, it pumps more money into the economy, it does more expenditure. So that is discretionary expenditure. Now discretionary expenditure is a need based expenditure. Some years it will be high, some year it will be low. Mandatory expenditure, it just stays in a particular range. Now the question is coming is that the states, they want more discretionary spending space. They want number one, more money, and secondly, they want to spend more money for the discretionary spending. The state says that right now the economy got impacted, we need to do more expenditure in health, we need to provide more support to the people, so give us more power for the discretionary spending. Okay, now something that they want this particular thing, but guys, the union government is not adhering to this particular demand. Then there is one more debate that is going on, the debate around the freebies. Now guys, understand this particular thing, that basically the central government, recently the prime minister even talked about one word, that is the Revdi culture. The prime minister said this thing, that today many of the state governments, they are promising some freebies, some entitlements, and the youth people are getting deviated by that. The prime minister said that people should not be deviated by this Revdi culture. So basically the freebies that are going on, around that there is a very big debate that's going on. So basically in this particular thing, the central government wants that the states should not go for these kind of freebies, but the states, they say that these freebies are actually the welfare schemes, and for that particular thing they have to give them. Moreover, now obviously when these freebies are to be given, for that more money is to be needed, and that particular spending will be called as a discretionary spending. So here also the state government need more space, but the central government is not giving that particular space. Then there is a sustained increase in the welfare expenditure by the state government. Okay, for example, now the people are to be for education, for health, more basically benefit is to be provided, more people are to be provided the coverage. So welfare expenditure has increased, but they are not having any additional financial resource, they don't have any financial avenues. In that capacity there is dispute that's going on. Then guys, understand this particular thing, that basically there is also one more issue, that how to spend the money. There could be two types of expenditure, there is a revenue expenditure and then there is capital expenditure. Now guys, the capital expenditure is that by which you are building some asset, by you are, for example, let's say the money is being spent for building the infrastructure, for building the highways, for building the ports, that is capital expenditure. Revenue expenditure is one which doesn't build any asset. So any expenditure, for example, being done to just pay the salaries and all that, it is a revenue expenditure. Now the center government wants that the capital expenditure should be more by the state government, but the state governments many a time had went more for the revenue expenditures. Now guys, understand this particular thing, that when we talk about the current expenditure, okay, now the borrowings are being taken, and these borrowings are not being used for the capital formation, which could contribute to the real income of the future, which in the long term can provide more benefits. Rather, the borrowings which are being taken, these borrowings are being used for the revenue expenditure. Already the government has provided this data, that the state government has a lot of debt by this Uday Yojana, by the farm loan waivers that have been given, by the populist welfare measures, the freebie that have been given. There is a lot of debt that is there into the state governments, and guys, in that capacity, if we see the debt to gross state domestic product, GSDP, okay, the GSDP has reached to 31.2% in 2022 budget. Now understand, basically debt versus state GDP. This ratio was earlier 22.6% in 2013. Now it reached to 31.2% in 2022. It means state governments are taking more and more borrowings. And those borrowings are being used for such revenue expenditure. So this is something that is being provided. So guys, understand this particular thing, that actually both the center and the states have their different opinions. State governments want more fiscal space, they want to spend more, but the center government basically is hesitant in giving that particular fiscal space because of the unsustainable level of debt that have been there. Just we have seen that the state level debt has reached to around 31.2%. So in this particular capacity, we need to come out with such a kind of a mechanism that the fiscal correction can be done. Fiscal correction can be done. Both can come together on a kind of a common ground and can understand that how this particular issue is to be resolved. So this is something that is to be provided here. Okay, so guys, that is all about this particular article. I hope that you understood this particular issue. Okay, now moving to the next article. There are no easy answers to the freebie issue. Okay, so there, let's take some questions. Sir, please share the highlighted PDF in Telegram. Dear, this question I had received many number of times, highlighted PDF. Now you see this thing. This is a highlighted PDF. I provide this particular thing. Now I have to provide at this particular level. Will you be able to read anything out of that? Now see, this is the highlighted PDF. If I provide this particular thing, many things are hidden here, but you will be able to read. So just this is the reason. Now suppose this is a highlighted PDF. Okay. So problem is that if I put this particular PDF, number one, this is to be put at this size only. You'll not be able to read anything out of that. Okay, that is one thing. Okay, fine. Then okay sir, please tell the timing of the class. So dear, the timing of the class is around 6:30. Sometimes it might get a little bit like 6:15 भी हो जाता है. Okay, थोड़ा सा कभी कभी 6:45, 7. It depends because on the number of articles that are there on that particular thing, because research, it takes a lot of time. So research, number of articles, so in that particular thing it depends, but the tentative time is 6:30. This is the tentative time. Around 6:30 is the tentative time. Now moving on, there are no easy answers to the freebie issue. Now guys, this particular freebie issue, the ones who are following the newspaper analysis regularly with me, now this freebie issue, it has become a kind of a horoscope which comes every day. You getting it or not? So every day I think the Hindu has reserved one particular section where they will be giving this freebie issue. Okay, fine. Now, so basically guys, the freebie issue, it's going on in the news from so many of the days. First of all, what do we mean by the freebie? What do we mean by the freebie? Freebie simply means the free entitlements that are being given. Okay, sometimes the irrational entitlements, for example, promising of the mixer grinder, promising of a TV set, promising of let's say a gold jewelry if a particular political party wins an election. These promises are being made, which are called as a freebie. Now on the freebie, there is a national debate that is going on right now. First of all, the Prime Minister referred to this freebie as a revdi culture. Then guys, the Supreme Court asked the center government that what center government has done to curb this freebie culture. Then the Supreme Court constituted an expert committee. Okay, the expert committee, that we need to constitute a committee of the Niti Aayog, the committee consisting RBI members, the committee consisting the Finance Commission members and others who will discuss this matter of freebie. Now I tell you that this entire background, okay, it has just become a like of an announcement that is done by an air hostess every day. Okay, anyhow, moving on. Now guys, the freebie. Okay, so basically this article talks about that when we talk about the freebie, they are just being seen as negatively by the political parties, but it's not the case. Freebies are not just a negative entitlement, rather they play a very important role. So here certain case studies have been given in this article. For example, Tamil Nadu's case study is given. Now it has been provided that Tamil Nadu come with the midday meal scheme way back in 1982. So way back in 1982, Tamil Nadu came with the midday meal scheme. At that point of a time, it was called as a freebie, but actually it has, and it was said that there will be a lot of leakages, there will be a lot of corruption. But today we find this particular thing that the retention, school retention into the Tamil Nadu got increased because of the midday meal scheme. The parents are sending their children to the school because they think that at least if they'll go to school, they'll eat something. So this which was called as a freebie earlier, it has been very much effective. Then moving on, understand in this particular direction guys, that actually, for example, you take another example, for example, bicycles for children. Now this bicycle for children might be called as a cheap electoral bribe, it can be called as a freebie, it can be called as just a irrational promise, but actually giving the bicycles to the children, it is very important into the rural areas because there is a very poor transportation, and because of that poor transportation, this is a very big obstacle in attending the school dropouts are increasing because accessibility to the school is not there, transportation is not there. In that capacity, giving bicycle to children, giving bicycle to the girls mean a very important thing. So therefore it's not irrational. Moreover guys, the television sets, giving TV is not about recreation, but TV is the vehicle for imparting the useful information to the people. Many times the women who are contained, who are just stuck in their houses, they don't know anything about the outside world, but they can get connected with the outside world. They can consume the news, they can consume the media, they can become empowered by the TVs. So they are not something. Now basically the article says that actually we need to make a distinction between the merit and the non-merit goods. Merit and non-merit goods. Now what are the merit and non-merit goods? Merit goods are the What are the merit goods? Merit goods are education, healthcare, fine. They are the merit goods. What are the merit goods? Which create the positive externalities. What are positive externalities? Positive externalities means the beneficial effects on the society. So for example, health, education, they have a positive effect on society. So therefore they are the merit goods. Then guys, after understanding this particular thing, that what are the non-merit goods are there, the who don't create any kind of a positive externality. They don't enhance the productivity of the people, they don't enhance any such kind of thing. Now politicians often have a better understanding than economists do of the merit. Okay, now basically it has been said that sometimes politicians, they have the understanding of the ground. When they go onto the ground, they know that actually what are needed by the people. For example, women, giving them the TV, it's not about recreation, it's about empowerment. So politicians, they have an idea that what is a merit good, and in that capacity they sometimes give some promises, and sometimes we need to see that particular thing in a broader perspective. Now it has been provided that recently the court has carried an intervention. What has happened? Basically court has recently constituted a 3-judge bench. Court has constituted a 3-judge bench and has asked certain questions to that 3-judge bench. What are the questions? Questions have been asked that number 1, what is the scope of judicial intervention? Can the judiciary control the freebie? Second question that has been asked is that what should be the composition of expert panel to examine the issue? So basically guys, I have just told you that the Chief Justice of India who got retired recently, he provided this particular thing that an expert committee should be constituted, and that expert committee will be seeing that how this freebie issue will be resolved. Then in this particular capacity guys, what happened? They say basically what needs to be an exact composition of this expert panel. Fine. Who will be the members of this expert panel? This is something that is to be seen by this particular panel. Then third, can the court pass any enforceable order? Can court come with a kind of an order that what needs to be done to curb freebie? This is something that was there. And then the fourth question, the scope of S. Subramaniam Balaji versus Government of Tamil Nadu judgment, should it be reconsidered? Guys, understand, yesterday we have seen this particular entire issue of the S. Subramaniam judgment. Yesterday there were the 2 articles on this entire S. Subramaniam judgment that came, and I expect that you have seen that particular thing. And if in case you have not seen the yesterday's article, I'll advise you that just go and see this particular discussion only, where I have discussed this S. Subramaniam Balaji judgment. In a case, I'll just tell you in nutshell, I'll tell you that what is this S. Subramaniam judgment. Understand this thing. Basically in 2013, a question was raised into the Supreme Court that when the pre-poll promises, the freebies, are being given by the political parties, can they be called as a corrupt practice? Can they be called as a corrupt practice under the section 123 of the Representation of People Act? Okay, in that particular case, in the S. Subramaniam Balaji case, Supreme Court said that no, giving pre-poll promises is not a corrupt practice as under section 123 of RPA. It means that now the political parties can promise the pre-poll promises can be given, and they are not corrupt practice. This is something that happened. So now the question has asked, can we reconsider this particular judgment of 2013? Can now it be made as a kind of a corrupt practice if some freebie is being given, if some poll promise is being given? So these are the 4 questions that the Supreme Court has raised for this particular expert committee that has been constituted. So that is also which has happened. The court has also provided an argument that freebies are unproductive expenditures and they needs to be reduced. But guys, understand this particular thing, that sometimes the freebies are something which are the lifeline of the poor people. Now when we talk about the lifeline of the poor people, now see this particular thing, sometimes employment benefits, economic benefits have not been reached to the poor people. In that capacity, the freebies are a lifeline of such kind of people. Now it has been provided that judicial interference is permissible when the action of the government is unconstitutional. Action of the government is unconstitutional. But understand this particular thing, that whether government's action is entirely unconstitutional when they are coming with the pre-poll promise, it is a debatable thing. It has not been made very much clear. Now guys, understand this particular thing, that the Supreme Court, they have issued guidelines earlier on many matters. For example, the Vishaka guidelines on the sexual harassment was released by the Supreme Court. Now why the Vishaka guidelines? Now guys, understand, the Vishaka guidelines is for the sexual harassment of women. This guideline came because at that point of a time there was no law which was protecting the women from the sexual harassment at workplaces. So therefore the Vishaka guideline came. Legal vacuum was there, but right now in this particular matter there is no legal vacuum. Already there is a Representation of People Act 1951. Representation of People Act is dealing with the corrupt practices. Corrupt practices mean what can be done and what cannot be done in the course of elections. So it is being dealt already by RPA. So why a new law is needed by the Supreme Court? So this is something that has been provided. Moreover guys, understand this particular thing, that when the job industry is very much lacking behind, jobs have not been created, privileged section of the society only got benefited. In that particular capacity, freebies sometimes are not actually the freebie, rather they are the welfare mechanism and they cannot just be discontinued. This is something that's been provided in this article. So that is all guys about it. I hope you have understood it, and now we'll move to the next article. The new facets of terrorism. New facets of terrorism. We'll see this article with respect to the GS paper number 2. Fine. National security, issues of terrorism. Okay. Even in GS paper number 4 also, the terrorism as an issue can be seen in the applied ethics topic number 6. There also we can see that. Now understand guys, that recently there are the 2 incidents of terrorism that have happened. One incident happened in Russia and one incident happened in the USA. So what happened? Number 1, first of all, in the USA there was the Salman Rushdie, the author of a book which became controversial. Fine. The Satanic Verses was a book that was written by Salman Rushdie. That book became controversial, and even the Iran issued a fatwa to kill the Salman Rushdie. Now the issue is that this book is more than 30 years old, 34-year-old book, this Satanic Verses, that was written by the Salman Rushdie. Okay. The Salman Rushdie book, Satanic Verses, it was written 34 years ago, and at that point of a time Iran issued a fatwa that this particular author needs to be killed. But now after 34 years an attack has been happened on this particular person. So this was the first terrorist attack that happened. Then guys, then there is a next attack that happened. What happened? Basically one of the women in the Moscow, one of the women in the Russia, who was an outspoken supporter of the Putin, she had even supported the Putin, had said that it was justified that the Putin has invaded the Ukraine. In that capacity, that women got attacked. There was a car, there was an attack on that women that was carried. So this is one attack of terrorism in Russia, and then there is another attack of terrorism in the USA. Now guys, see, you don't need to go and read the details of these particular things, that okay, at what time, at what place they got attacked, what they were doing at that point of a time. So these details are being provided here in the article, not important for your examination. Now what this article is raising, this article is raising a very fundamental kind of a question. This article is saying that when we talk about the USA, now USA has such sophisticated agencies. They have the FBI, they have the CIA, they have the artificial intelligence. Through the artificial intelligence, through FBI, through CIA, what they are doing all the time, they are snooping onto the personal data of the people. They are just going through the personal data, and they are trying to make the patterns that nobody is trying to endorse the terrorism. No such kind of a planning is being done. They are trying to capture more and more intelligence against the terrorism. So USA is doing the same thing, and at the same time the Moscow, all the time the intelligence agencies and the law enforcement agencies of the Moscow, they are trying to retrieve more and more intelligence information so that they can nab the terrorism and terrorist activities. But guys, even these two attacks tell us that when it comes to terrorism, first of all, there is no difference between a democracy or a state controlled or there is no difference between a democracy or the country such as Russia, which is highly controlled by the state. Every country is prone to the terrorism. So the democracy or a heavy-handed security state, both are prone to the terrorism. Moreover, understand this particular thing, that the democracies, autocracies, all are using the same tools of spying on the citizens. Private information is being snooped, it is being collected, it is being on that particular thing. Artificial intelligence is being used. Both the countries are doing that thing, but still they have not been able to deter the terrorist attack. So basically it is being said that all the security drills, all the knowledge that has been accumulated by the security agencies over the years, all this particular information, all this knowledge, all this expertise, all this particular drills that they have carried are useless, and they have become ineffective in controlling the terrorism. So basically guys, in this article, much deep substance is not there, just it is raising these fundamental issues that terrorism is actually enemy of every country. It doesn't matter whether you are a democracy or whether you are a very heavily controlled state such as Russia. Terrorism will impact everybody. So at the end of the day, we all needs to come together against the terrorism, and we need to fight the terrorism. Okay. Moreover, the intelligence, the artificial intelligence, the technologies, the spying technologies, whatever are coming, they have also become ineffective against the terrorism. So this is something that has been discussed in this article. So that's all. And now we'll move to the next article. RBI mulls fraud registry to help check banking frauds. Now this article will see with respect to the GS paper number 3. GS paper number 3, digital economy. Okay. Now what's this article talking about? So guys, in the past we have seen that there are a lot of cyber frauds, the financial frauds that have happened with the people. For example guys, you might have known this particular thing, that somebody is calling you asking for an OTP. Fine. Or you might have heard that somebody in your relatives or some of your friend, they got a phone call, they clicked on a link, and by that clicking on that link, their account, all the money was stolen from their account. Or these financial thefts, financial frauds, they are increasing. In order to reduce that particular thing, the Reserve Bank of India, it is setting up a fraud registry. Now what is this, a fraud registry? This fraud registry will be a database of all the fraudulent websites. This fraud registry will be a database of all the websites, phone numbers, and various modus operandis. Okay, understand this particular thing, that this registry will contain the list of all the websites which will dupe the people of their money, all the phone numbers which are being used by the hackers, the phone numbers which are being used by the fraudsters. And the moment this particular information will be listed on this particular registry, what will happen? All these websites numbers will be blacklisted by the police and by the enforcement agencies. And over a period of time, all the ways by which they operate, all the phone numbers, all their websites will be getting blacklisted. Moreover, the people will also get the information, as they can see that whose numbers have been listed on this particular registry, what are the modus operandi operations. Moreover guys, all this particular information will also be provided to the payment system participants. For example, Paytm, PhonePe, they will also be given the information that how now the financial thefts, financial frauds are happening. So by that particular thing, they can also go for the fraud monitoring. Now guys, this particular aggregated fraud data will be published to educate. Now this particular fraud data will be published to educate the customers on the emerging risk. So this is a way that how the digital economy will be, the digital economy which is growing, its footprint is growing, how it will be make sure that it is safe for the citizens accessibility. So guys, understand this particular thing, that as the digital economy's footprint is increasing, the people who are vulnerable of the financial frauds, they are also increasing. So in order to protect them, in order to educate them, this fraud registry, it is going to help. So that's all guys about this particular issue. I hope that you have understood it. Okay. However, just these two-line concept is there. Number one, a registry or a database will be created where all the numbers, websites will be listed, and secondly, they will be blacklisted once the information is published there. And thirdly, people will also be getting to know about that thing. That is all about this. Nothing beyond that. So that is all about this article. And with this, we come to an end to the today's newspaper analysis. Now, guys, we'll be meeting tomorrow. Till then, please take care of yourselves. And guys, if you have liked the video, only if you like, please do hit the like button. Please do subscribe to our channel, and also please do leave your lovely comments. They motivate us and they further push to work even more harder. Okay, so that's all. Now we'll meet tomorrow. Thank you so much.